can't get a hit here and there to keep us in business and keep us going, you know, the government is not going to provide an attorney to defend your civil rights in federal court. There are 60 parent counsel, give or take, in the state of Arkansas. Those are the ones that get a whopping $800 to represent you no matter what it takes, and that they can't do it. They can't even subpoena a lay witness on your behalf, right? 60 of them. Not one of them is going to even consider filing a federal suit on your behalf, and not one of those ad litems is going to consider filing a federal suit on behalf of that child, even though we know their rights, and they will admit, possibly, no, they're not going to admit anything, I'll take that back, but they know that rights are being violated, not being represented if that's not the case. And if we don't, look, we've asked for money before. I have on cases, you know, keep going, help us. They'll give $1 million to get surgery for a cat. You know, some things are popular. Some things are not popular. This is not a popular subject, and I think it turns some people off, people that don't know. Okay? The people that do know can't afford to click that button and get us anymore. That's the problem, because the people that are victims and the people that know the truth because it happened to them can't afford to help the Stanleys. Can't afford. I could file if I had 5 of them. Here's the funny thing. Parent counsel in this state to go to kitty court they have a budget of $2.5 million in 2015. They're trying to get more. I said, you know what? At least I got through qualified immunity. You know, I would be willing to consult with you and help you guys file them, because you know what I'm saying. They got 60 lawyers, right? So the response that Brian gave me, he's the director of parent counsel, was he said, Joe, you know, I don't have the budget or the manpower for that. He said, I don't even have the money to make the copies to file a federal lawsuit. And I'm thinking, you got 60 lawyers and $2.5 million. And that's what I told him. I said, I've done it by myself. You know, made the copies my damn self on my copier. You know, you can't do it with 60 lawyers and $2.5 million, and I can do it by myself. That shows that they don't care. They have no intention of doing it. And I didn't even ask them for money. I said, I'll consult and help you. You know, so. The desire is not there, the fire is not there, the leadership is not there, and it would take, we would have to clean the whole house all the way across the board to make a difference that we could discern what you and I are, is what I'm afraid of.
We have a question online, and they're wanting to ask you about the children that are put into the juvenile homes, you know, and it's been reported that they're being sexually assaulted goes up 28%, and being drugged. The person that's asking this question, their child is being drugged in the system. They're not being able to get help. What are things that they can do, or can you kind of talk about that?
Well, the Families First Services and Prevention Act, one of the sections of that gets rid of group homes.
Okay.
So now let me tell you, this was sponsored by Vern Buchanan out of Florida, and then in the Congress. And then it was sponsored by Senators Wyden and Hatch. And it flew through Congress in 2016. And then, of course, we had the election. It got stalled in the Senate. And it could not get passed in the Senate by the end of 2016. So it sat doing nothing for 2017. In 2018, they snuck it into the Omnibus Budget Act that passed in February. Okay, so you probably heard a little bit of talk if you watched anything. The Budget Act was like 6,000 pages or something, so of course not everybody read it. So they were able to slip it in here, but here's what happened, is this is the same one I was talking about, that takes the Title IV-E money and says that, okay, the states can use money from the Title IV-E budget for the first 12 months. It also gets rid of group homes. It is optional. That's the only way they could get it passed, was to put in there that it's optional for the states. They don't even have to do it. So we have to put pressures on our state legislators to say, you need to go to the agency and say, why aren't we looking at the Families First Preservation and Safety Act and making it part of implementing into that? Because if you're worried about your money, here's a way you can get your money and still, you know, do things for the families in advance. So unfortunately, you know, a few people probably need to be sued. You know, here's the problem. I mean,
nonprofits in Arkansas usually.
Yeah, and they're nonprofits. Here's the problem. I was telling you about a young man that I did the civil rights suit, that he was sexually assaulted within the juvenile detention center. By the grace of God, his stepmother came to visit him right after this happened. Okay? He comes into the visitation room, breaks down bawling. She's like, what happened? What happened? What happened? they say, and they get the sheriff over there, and there's freaking DNA. Okay? There's DNA. Now,
Don't
again,
rejoice too soon. She doesn't know the end of the story.
no, that story is not over. I can't even win with freaking DNA, and that's a whole, I'm still in the process. But how many times in a group home, I mean, we all know the status all over the nation of people reporting sex abuse and people saying it's false and whatever. You know, you can't get these victims in group homes, if they tell their story, they're probably not believed. Okay, or they go tell the story to somebody, they don't get the cops in. Cops do terrible investigations. Even in my case, the cop did a terrible investigation. He didn't get the video recordings. He didn't, just a whole bunch of stuff. Okay, so, but that was the only way that I was even to even think about filing a lawsuit in behalf of that child. Had I not had the DNA evidence, I wouldn't even have thought about it. I have put 700 hours of my work and $50,000 in cash, just trying to get depositions done, just trying to get to court, and I'm still not here.
The next question follow-up is, she wants to know, can they medicate the children in the group homes or in foster homes without telling the parents?
Yes. They're not supposed to.
They want.
Okay, but legally, we're talking about, I know we know, but legally, are they supposed to, what is the protocol? I guess what she wants to
Legally,
know.
at least in Tennessee, parents, as long as they have parental rights, have the right to object or consent to medical treatment. Legally, as long as they still have parental rights. If they're just in the custody of the state, they still have to give the parents consent.
We don't hear it, by the way. When DHS takes your child, they have full authority to do whatever they want. There are boxes that are checked on your orders, say an adjudication order where the child stays in the care of the state. There's going to be a box there that the judge can decide. Do they have access to school records? Do they have the right to make a decision? Okay, I'm very, very rare to see anything checked. Yes, it's just no. Full authority of the state to do pretty much anything they want except amputate. There's that paragraph in the bottom of it. They can't amputate a leg, and I don't know how often that comes into play, but that illustrates the power that the state has. They can do basically anything except cut off a limb.
Well, and the judge can order, I mean, they can do that in Tennessee too. The judge can say, well, I'm going to give the power to the state.
Well, they do that here in every case. It's just the way it happens. So no, probably legally or not. I don't think these things that are done legally are legal if they violate the Constitution. But Keisha Smith told me we're not subject to the Fourth Amendment. That's, I think, exhibit number 2 to the Stanley suit. And Senator Clark and I were talking to her at my office, and she said, we're not subject to the Fourth Amendment, and we kind of went on. And really, I thought she was kidding. If I had known she wasn't kidding, I wouldn't have wasted any more time there. But she said that's civil. We have a law, and there were 2 statutes, 1218-608, 1218-609, that says if I'm an investigator and you don't let me in your house or you don't let me see your child, I have a right to go to a judge and get an order of investigation. Okay? The order of investigation is a wolf in sheep's wool. It is not based upon probable cause. It doesn't satisfy the warrant clause in any imagination whatsoever. It can be hearsay. Okay, so not only does it not satisfy the warrant clause in the fact that it has to be probable cause or an oath or affirmation, in other words, not hearsay unless they can prove the hearsay is reliable. Okay? None of that matters. The problem is the remedy or the power that they put in this order, that investigator can enter any place a child may be. Okay? Now the warrant clause, even if you swear it out, you have probable cause, oath or affirmation, that a warrant is limited, you say right to be free from unreasonable searches and seizures. Okay? Except upon probable cause, sworn by oath or affirmation, and particularly describes the places to be searched and the persons or things to be seized. That's why when you see a warrant, it says yellow house with gray shutters. Particularly, this gives these workers the power to enter any place a child may be. Okay? So I'm thinking, well, there's a slam dunk. That's unconstitutional. You know, I could have figured that out probably in high school. Okay? But the problem is, it's not unconstitutional. I brought a petition for declaratory judgment here. Oh, and also, by the way, they can take your child and x-ray him and shoot him full of radioactive dye. They can enter their orifices and they can do anything they want to your child. And this is in the course of the investigation, right? That's what this order of investigation allows them to. So I filed a petition for declaratory judgment. It's on appeal now, but the judge said I don't see anything wrong here. So then that was the state court juvenile judge who decided that. And my appeal basis is in order to not make bad law and let our Supreme Court say there's nothing wrong here. That was when the sovereign immunity ruling came out. So they had already dismissed a whole bunch of my stuff under sovereign immunity. I thought, I'm going to take advantage of this. That's a state judge. I'm asking for money damages. That judge did not have the jurisdiction to decide that case at that time. And we'll see. I'm going to figure out how to lose a case with the same facts both ways.
Yeah, and let's talk about these courts. Do you know where the term kangaroo court came from? Do you remember who first said it? Kangaroo court? I get in trouble when I refer to juvenile court as kangaroo court. It was first said